Hotel Liability for the Guest's Property from Common Law Through Today by Abby Karen. So if we look at the history of hotel liability, innkeeper's liability all began way back in the Middle Ages. It was at this time innkeepers were responsible for all protection of the traveler, since roads were long, dark, and dangerous at night. Fast forward hundreds of years to where travel is fast and safe, statutes have been added to the common law liability. This strict law of innkeepers made liable for any and all losses or injuries to the traveler. Hotels nowadays don't have as much responsibility as they did back then. Courts have ruled that innkeepers are to ensure the safety of property and their guests unless such losses come from act of God, a public enemy, or the neglect of the guest himself. States in today's time have modified these statutes and their limits in the liability to each of the hotel. Under common law, an innkeeper or hotelier will be liable for loss or damage to the guest property for the full value unless the loss was caused by an act of nature, a hurricane or a tornado, civil unrest, or the fault of the guest himself. Today, this general rule still exists, but states have modified the common law by enacting statutes that limit the hotel liability, provide the hotel complies with the statutory requirements, although amounts can vary from state to state. Liability ordinary is limited to a specific figure, which can typically range from $250 to $2,000. For example, the Massachusetts statute states that innkeepers are not liable for losses sustained by guests except for wearing apparel, luggage, or money for travel expense and personal use. In the event of such a loss, the innkeeper is not liable for more than $300 in any loss. However, if the loss involves the loss of money or jewelry that is deposited for safekeeping with the hotel, the innkeeper will then be liable for the amount up to $1,000. However, even though a hotel is limited by the statute, the limitations are only allowable as long as there's plenty of conspicuous signage in every single hotel. There are the availability of safes in either every single room or a giant safe that is available 24 hours a day, and that there's a time frame when guests can get to and from the safes. If the safe closes at 3 p.m. and check-in starts at 4 p.m., a guest would not be able to put anything into the safe, and therefore the hotel could be very liable. If any of these limitations are not met, the hotel could lose and be liable for a whole bigger losses. Hotels need to make sure that they are aware of their state's limitations and making sure that they can fix any problems that come their way when it comes to being held liable. Having hotel management familiar with states' laws and statutes could be the difference from losing $250 to $250,000 from being held liable.